included a motion to dismiss and also a counterclaim. Just barraged the other side. Sent a pre-mediation settlement offer where he's going, put up or shut up, and he stuck to his guns. If you're right, that's your strength. It's where a member fights back against MCM using their own documents against them, truly. Hey, got a good one today. Brian Parker here with another interesting video. These I enjoy doing, case studies, meaning members that have used our services and have successfully beaten the bad guys. So I like doing these because they're accessible and practical, and people can learn a lot from empathizing either with what the person's going through because you're going through that, or because it's real people, not just some dumb attorney telling you what to do. Although I hope you like what I have to educate you with. So the lessons from this case study, it's where a member fights back against MCM using their own documents against them, truly. So the lessons, Shazam, we're going to learn today. This member found an impossible timeline. The debt was sold 6 months before the original credit was able to give it to him. The member in his state, I believe it's Georgia, challenged the combining of 3 counts into one lawsuit. The rules there don't allow that. Pointed out missing affidavits. He actually sent a pre-mediation settlement offer. He's got some cojones. He actually gave the lawyer and the debt collector a deadline that they should meet his deadline or he was moving on. And then when it came a sticky situation, he stuck to his guns. And he clearly articulated his issues to the judge who got it. And that's always good, whether you're pro per or an attorney. That kills me sometimes when the opposite is true. When you show a court 2 + 2 = 4 and they go, yeah, it's 56. That drives you nuts. So it's good when a judge does his or her job. The judge's response, Shazam, he recognized the date problems were peculiar, acknowledged insufficient evidence. He ruled for the defendant, and he gave Midland 30 days to appeal. It's unlikely they will. So attached to this video, the important stuff that you'll need, the member wrote him an answer in which he included a motion to dismiss and also a counterclaim, just barraged the other side. While that's probably not how it is done in Georgia or anywhere else, hopefully it is, it was enough to make his case and detail it and make it strong and scare off the attorney. The member's narrative, I'll show you his narrative on how he won. Bits and pieces here. My show notes, 18 pages drawn from what he told me. So what happens is, and I invite you to do this, members will go, hey, I beat this company and this. And I'll go, hey, whether it's YouTube or it's my member site, can you send me to Brian at KillDebt.com your documents in Word so I can give them to the members? Also show me the judgment where you won, show me the original lawsuit, all that stuff that I can pass on to everybody for the education. So the show notes, plus I have created a checklist. You know I love my checklists. I love them for you. And what I did is I took this member's battle and victory and put it into a checklist for you, a couple of pages. So when you have a Midland Credit or a debt buy or any lawsuit, it'll show you exactly what things to look for, what to fight with, how to get a victory from the checklist. So you know I love my checklist, so you'll get it. Please remember, KillDebt 2.0 is live. We're getting feedback from members telling us, hey, this needs this needs this. Please don't hold back. Be patient with us, but tell us what your needs are, if there's any bugs or anything, so we can make the site better for everybody. Like, love, and subscribe to this YouTube channel, but also come and be a member at KillDebt.com. It's less than 1/10 of an attorney. I think it's like $5 a day to have this brain in ParkerGPT that's now supercharged to respond to every prompt or question you ask and spit out everything you need, does all the work for you. So let's take a look at what happened here in this case study against Midland Credit Management. So I'll give you the first paragraph, what the member said to me, Shazam. First things I thought were odd was bringing 3 different credit card accounts into the same action when all the facts were different original credits, etc. Of the 3 accounts in the complaint, the Destiny card which the original creditor is First Electronic Bank, is the only one with an affidavit saying something happened. The other two only had bills of sale. That's important. The Destiny card chain of title assignment was glaringly wrong. The date on the bill of sale from the original credit to Concordia credit is 4/8/2024, but the bill of sale where Concordia is selling something to Midland is dated, it looks like 6 months earlier, 11/28/2023, before the original creditor ever assigned it. The original creditor is First Electronic Bank, before it assigned it to Concordia. So let's look at all that and everything else that the member found after analyzing the lawsuit. So when you get a lawsuit, collection lawsuit, take it, break it down, take a second on the side of each paragraph, true, true, false, false, not much will be true, and why. Look at their documents. I've got tons of checklists on how to do this. But in this case, it was a broken chain of title, which most of them are, but you're gonna see how the member, just like you, broke the thing down. Shazam, here's the actual lawsuit. It was filed in Georgia, and essentially they're saying defendant owes a bunch of debts, but isn't specific. It says the amount without any clarity and attaches a bunch of documents. So let's take a look at the documents. As he said, let's put it up there again. The first thing I thought was odd was bringing 3 different credit accounts into the same action. So that's him breaking the lawsuit down and going, this is odd, you should too. When all of the facts were different original creditors, etc., they had one bill of sale that didn't make any sense, but was backed up by an affidavit that didn't make any sense, and the other two only had bills of sale with no affidavit. Here's Shazam, the first bill of sale. There you go. The original creditor, as I recall, is First Electronic Bank, right? So here, this is signed 4/8/2024, and this is between First Electronic Bank and Concordia Credit, who originally sells it to Midland Credit 6 months earlier. So you can see First Electronic Bank is the creditor signing something away April 2024, 6 months after the seller here gives it to Midland Credit, when the buyer, Concordia, doesn't own anything. So as the member says, the bill of sale from Concordia to Midland is dated 11/28/23. And here's that bill of sale, Shazam, and that's Concordia Credit. And you can see right there, November 28, 23, they're selling something in a sale file to Midland Credit Management. Obviously, it's not the client or the member's debt because it's 6 months after the person he contracted with. It's 6 months before his debt was sold to Concordia. Keep an eye on that last paragraph. This bill of sale is delivered pursuant to the receivable sale agreement. That's your forward flow agreement. And every time, as it says, bill of sale is delivered pursuant. Again, when something's done pursuant to something, it's largely dependent on the thing it is pursuant on. So that must be attached. I say that to you because had this case gone down the road to really push some buttons and put a foot on the throat of MCM, you ask for that agreement. It's the forward flow agreement. They don't like that. And that's how you settle cases too. And if you look at the sale signatures, there's no date on either one. A contract is no good without a signature and the date that its effective date. Now, it says a closing date, and that's what we key upon, as the member did here. Attached to that bill of sale, Shazam, was an affidavit of sale of account by the debt seller, in which the debt seller says under oath, 11/28/23, debt seller sold a pool of charge-off accounts without any specific account to the member, and by a loan sale agreement and a bill of sale. Well, they're saying under oath, we sold this thing to Midland, even though they're aware the original bill of sale from First Electronic Bank didn't sell supposedly the member's debt till 6 months after in 2024. And an attorney there is writing, oh yep, everything above is true. I saw him sign off. So that's a whole plate of wrong. Of the other 3 debts, here's a bill of sale, Shazam. That's Community Bank selling something to Midland Credit. And at the bottom, they have dated it 12/20/2023. and 12/28/24. So it's not effective until 2024. And there's the other bill of sale for the third debt in this lawsuit. Community Bank again, 11/24/2024, 2/28/2024, which shows you they know how to sign and date at the same time. So the member says the following, Shazam, in both of those other accounts, the seller and buyer signed agreements several months apart from each other. The account page is an example of at the bottom of the page. So each bill of sale came with what the industry calls a data form. And it just breaks down how much is owed, when the debt was signed up for, last payment, first payment, all the good stuff. And at the bottom, this is what it said, Shazam, the account information provided Community Bank pursuant to the bill of sale and assignment of accounts transferred on or about 11/20/23. So the member points out the seller didn't sign the bill of sale until 12/20/23, and the buyer Midland didn't sign until 2/28/24. So how are they saying that everything was transferred a month earlier? And again, he shows Shazam, this another data form where at the bottom it says account information provided by Community Bank 12/20/23 in connection with the sale of the other stuff. And again, that was a month too early. So he did something unique. He first took all this information, as I counsel you, and he put it into his answer. And in that answer, he put a motion to dismiss and a counterclaim, and he bundled it all together just to slamma-jamma them. And I attached that whole answer in Word for you to this video and put it into ParkerGPT so you can use it. And then after doing all that, he received a notice in the mail that he has to go to a mediation. A lot of courts force their cases, especially collection cases, into mediation to try to resolve them. Otherwise, the court gets clogged up. And so he sent a pre-mediation settlement demand letter to the attorney for MCM. I really like this guy and the cojones on him. I'm not going to say the words, but he's really got chutzpah, as they say. And he writes in the letter, I'll give you the first page, Shazam. I'm writing as a self-represented defendant following the filing of my answer, a motion to dismiss, and counterclaim. So I always counsel right up front what you're doing, right? And I offer to resolve the matter on the following terms: a dismissal with prejudice, complete removal of all negative credit reporting, a written agreement these alleged debts will not be sold or transferred, a mutual release with confidentiality provisions, and number 5, settlement execution within 10 business days of acceptance. And he tells them, your complaint violates Georgia law, it's up there, by joining 3 separate unrelated credit card accounts in violation of OCGA 9-11-20A. Joint claims must arise from the same transaction or series of transactions involve common questions of law or fact. So he's already pointed out that these are all separate things that they've clamped together in violation of Georgia law, probably in your state too, because everything has to emanate from the same transaction or occurrence, regardless of what it is you're pursuing. So he says there's a chain of title problems in this same letter, Shazam, timeline problems, assignments dated inconsistently, generic language, assignment documents that fail to specify the actual accounts, multiple entity signatures, and jurisdictional issues. In this case, a Florida attorney certifying documents for a Georgia case while citing New York property law. You've heard me talk about that in a lot of MCM cases. But this is what I like about what he said. He says, Shazam, I want to note that the DeKalb County Magistrate Court proceedings are broadcast live to the public. If this settlement offer is not accepted and proceeds to hearing, my argument and systematic problems outlined above will be public record, meaning everybody will see them on the public record and on the camera, which could provide valuable, fatal defense strategies for other defendants facing similar claims. So he's really showing you better deal with me. And he's not making empty threats. You never make empty threats. If you got it, say it and support it. And this is one of my favorite things he does, and you'll see why. Shazam, This offer expires at 9 a.m. Eastern Time on Wednesday, October 29th, a day before our scheduled mediation date, to allow adequate time for your client's consideration response. He's saying you better settle before then. They always blow you off, so big deal, right? Well, guess what? So he goes, and I'll just put it in his words, I'll put the paragraph up, Shazam. I should say DeKalb County Magistrate Court is all virtual, and that DeKalb County requires a mediation session before having a hearing. At the mediation meeting, the lawyer that filed the complaint was not there. That's a common thing. Someone from his office stood in. Usually they just contract out. She asked if I was ready to settle this and get it taken care of, to which I responded, check this out. I sent a settlement offer 2 weeks prior to the lawyer on the complaint with no response, and that offer has expired. I love that. Sorry, I gave you a chance, you had 2 weeks, and you blew me off. We could have the hearing now, and we could have the judge decide on the validity of Midland's standing in each case, let alone the fact you filed the accounts as one case, is what he told them. So they told him to go pound sand, so here's what happened. I'll give the paragraph. Shazam. We then were in front of the judge virtually. Midland explained the case and their position. The judge asked me, to which I said they had violated the law with the combining of the 3 suits into one separate fact, statute of limitations, and beyond that, they couldn't prove a valid chain assignment. So that's a disciple of our channel. Judge looked at the dates on the assignment docs. This is all he asked from a judge, is to take a look, and then looked at Midland's attorney and said it was peculiar how the dates didn't agree. Don't you love this? Then asked about the affidavits for the other 2 accounts, to which the lawyer said she had none. So this poor lady thought she was settling the case today. Now she's in the throes of this attack from the judge and from the unrepresented person. She thinks she's all that, being an attorney. Now she's got to actually do a job. But there was a credit card statement for each one, she said. The judge said, that's not enough. I am ruling for the defendant. You have 30 days to appeal my ruling, and that was that. Want to see the judgment? Shazam. So that's the judgment, and it says, judgments entered in favor of defendant. Plaintiff did not file business record affidavit, and therefore plaintiff's documents were not able to be reviewed as evidence. That's them not fulfilling their burden of proof. That's the judge saying you didn't do it. And he's asking for affidavits. And again, I always counsel you, get your counter affidavit in there. It's gonna rule the day. So this guy did great. Again, the lessons I opened up with, the member found an impossible timeline. Let's put it up there, the lessons again. Challenging combining 3 accounts in violation of the law, pointed out missing affidavits, sent a pre-mediation settlement offer where he's going, put up or shut up, and he stuck to his guns. If you're right, that's your strength. Right is might. Clearly articulated the problems to the judge. If you, as I counsel him, anything, emotion, anything that you're talking to the judge, make it easy to the judge, for the judge, and they'll make it easy for you. Clearly articulate what you want and why, all right? So again, attached to this video is the member's answer, a motion to dismiss, and counterclaim in Word for you in a form, but more importantly in ParkerGPT. So just go to ParkerGPT, put it in the prompt space, click the rocket ship, it'll tell you how to better ask that question, and you will now have an answer to motion, dismiss, and counterclaim that won it in this case study. His narrative, you'll have the member's narrative, my show notes, 18 pages of instructions based on this case and case study, and my, I always do that because I love my checklist, a checklist of how you can take your own case and it'll break down exactly what you look for, what to do about it, where it goes in your answer, and the outcome that's possible if you follow what the checklist says. I love giving you checklists. The new website, it's the same, it's a update 2.0, will have the capability. You'll have when you sign in or you're already a member, you'll have a briefcase, and it's called My Briefcase, and one of those briefcases will allow you to do your own checklist. So you'll have a checklist. I've got possibly 100 checklists in there now, all inside and embedded in the brain of ParkerGPT, which is better than my brain, and it's super powered. You just upload your document, tell it what you want, press the rocket ship if you really want a good question to ask it or instructions. And then if you follow what it says by pressing the rocket ship, it does it all for you. It'll spit out exactly what you want. Your filing, your notice of hearing, your proof of service, things to do, how to settle, how to file, how to do them, what to do. You can put in, hey, the debt collector said this, this, this. Should I accept that? And it'll say yes or no, depending on the good information in, great response out. So go check out KillDebt 2.0. I made you wait, I'm sorry, but we need to get it as close to perfect as possible. I've got so many things now in KillDebt.com, case law, my briefcase, archives. You can bookmark your videos. So anything you've seen goes into your briefcase. Any document you want to check out goes into your briefcase. Any documents you created into your briefcase. You got to chat with ParkerGPT, and believe me, they get extensive. I think we have a 4-hour maximum now. That doesn't mean you're stuck at 4 hours. Just keep going later on. It's all in my briefcase or your briefcase. And this website is for you. Just like this case study I sent to you today from a member. I hope it helps. It helped me. I used ParkerGPT. It's just a good way to go because it's in our lane. It's strictly only debt defense. So we're not hindered by hallucinations and other nonsense. It's just for you. ParkerGPT rules. Thank you. Like, love, and subscribe too. Thank you. Bye.